You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Judge, can I get the case number, please?
255-30.
This is your standard Miranda warning, but don't let the calm tone fool you. Being charged with theft in Texas, especially one involving multiple incidents, is no small matter.
Pause right here, because this is where people underestimate the situation. In Texas, when theft involves multiple incidents across different locations, prosecutors don't look at it as one bad decision. They look at a pattern of behavior, and patterns turn misdemeanors into jail time fast. So while this sounds calm on paper, legally, this case is already heating up.
Up to a year in jail and thousands in fines, the stakes are real.
536.
3536?
Ready?
Yes. On December 17th, 2024, an officer reviewed an OR, an offense report of a theft on September 17th, 2024. According to the report, the complainant reported that the defendant, known to the complainant by name and site, stole 2 espresso machines on August 9th, 2024. The complainant stated the defendant committed the theft at 3 other store locations. The officer reviewed documents that there were theft incidents at 4 home goods locations. The first incident occurred outside of Harris County, Texas. The second incident was investigated by the Harris County Precinct 4 Constable's Office. The third incident occurred on August 9th, 2024, where the defendant and an unidentified female entered the home goods and entered.
Hold up. Did you catch that? She ran to the back of the store, grabbed sheets, tried to return them without a receipt, and then walked out with them when it didn't work. That's like robbing a store with a receipt scam speed run. Wild.
The line to make a merchandise return. Once in line, the defendant ran toward the back, where she selected 3 sets of sheets and then walked to the front of the store and rejoined the female in line. The defendant then placed the sheets on the counter and provided the cashier with her state ID. The system denied the non-receipted refund due to excessive returns without a receipt. The merchandise was then returned to the defendant. The defendant and the unidentified female that left
And this is the moment the defense starts sweating. Surveillance footage plus a booking photo match isn't circumstantial. It's visual confirmation. Juries trust their eyes more than testimony. And here's the real question. When the same method shows up across multiple stores, does this stay theft? Or does it start looking like organized retail fraud?
Had left the store passing all points of sale without attempting to pay. The value was $599.99. The fourth incident occurred on August 9th, 2024. The defendant arrived alone at another home goods location and proceeded into the store with an empty shopping cart. The defendant.
This is where the evidence locks in. Surveillance footage plus a booking photo match? That's a tough combo to beat in court. Question for you all. If someone pulls this kind of repeat scheme across multiple stores, should it still be treated like petty theft?
Selected 2 espresso machines and then walked to the front of the store and passed all points of sale without attempting to pay, and the security sensors went off. The value was $999.98. The officer reviewed the surveillance footage from the third and fourth incidents and compared them to the defendant's previous booking photo, and they were a match.
All Marshall's Home Goods? Is that what it is?
Yeah.
Okay. She's on bond for a theft. She's on bond for a gun case with us now. Where is the first theft?
The first theft.
Now that's a judge laying down the law. Notice how they're not just throwing numbers around, they're setting strict boundaries. GPS tracking, retail bans, drug testing. This is a full court press on behavior control before trial. Effective? You tell me.
Is from a Walmart judge. $121.
Ms. Beck, I'm going to find that there's probable cause to go forward with the case, and I'm going to tell you now, I will do everything in my power to protect every person, place, thing in this county. And if I have to put you in custody and make your bond $50,000 because you continue to become a danger to our city, I will do it in a heartbeat. Do you understand me? I'm ordering you not to go to any Walmart, any Marshall's Home Goods, in anywhere. And I'm going to put a GPS monitor on you so I know where you are at all times. You are not to consume alcohol or illegal drugs. And I'm sending you now for a test so I know what, if anything, is in your system. You're to test and then you're to come right back. Do you understand?
Yes, sir.
Do you have a job at this time?
Plot twist. The defendant is also a complainant in another case, in the same court. This raises big questions. Could her credibility be affected? And how does a judge juggle fairness when the roles flip like this?
What do you do for a living?
I'm a reservationist.
Okay. I want proof that you have a full-time job because that is now a condition of your bond as well. I want to make sure that you're working full-time as well.
And Your Honor, the defendant is also a complainant in this court as well. I need to bring up, we've reassigned these cases so that we can deal with it, and so it's on separate prosecutors. Like, I have the other defendant's case assigned to me, and Abigail is assigned this case. If that makes sense. She is listed as so she is listed as the complainant in a separate case also in Court 5.
In what regard?
So she,
Like in an assault or something like this of this nature?
yes, it's an assault, Your Honor. And to.
Okay, so you divvy it up how you want.
Yes.
Yes.
Because I don't want her to pick up fourth case.
Right.
No, we just want to
Sure,
make you
that-
aware, Your Honor.
Yes.
I'm also ordering you not to be in possession of any weapons. Do you understand? These are your bond conditions. You violate these conditions, I'm going to revoke all of your bonds and I don't understand why you're having attitude. You have now 3 cases. You're rolling your eyes as if you have some kind of. We need to talk about bond. What do you suggest as far as a bond in this case, on the newest theft case?
We would suggest a surety bond on the case, Judge, and leave it up to your discretion in terms of amount, but I don't think a PR bond would be appropriate here.
Well, if you do make it a surety bond, we'd ask for it to be low. She did show up here on her own volition today. And I think she's, at least for today, showing the right attitude about how to handle this from here on in.
So the bond gets set, then immediately converted to a PR bond just so she can be drug tested. That's an unusual move, but it shows how the system bends in real time to enforce immediate compliance. Courtroom chess at its finest.
Set your bond at $2,500. Cash surety. No more PR bonds. Do you understand? I want to send her for a drug test right now.
This isn't just about stealing merchandise. It's about control, credibility, and whether the court believes you can follow rules when no one's watching. One more slip, and this case doesn't end with conditions. It ends with custody.
So, Felicia,
Judge, I can't send her until the bond has been posted, or else they'll take her into custody.
okay, then I'm going to give her a PR bond for now because I want to send her right now.
Yes, Judge. I'll still have to wait till that trial starts.
Yep, go for it. Okay, I'm going to set the bond at $2,500. I'm going to give her a PR bond because I want to send her for a test now. You were to test and then you're to come back. Do you understand? Not leave until you sign our bond conditions. Please take a seat.
Do I have to be back here when she returns?
No, I'm not. I want to know what, if anything, is in her system, but I want proof within a week of today of full-time employment. Okay. And then depending on what happens with the test, when we come back in a week, we'll talk about how to go further.
Okay.